Hello and welcome to Roundtable. If you make billions from fossil fuels, if you help to pollute the world, then you will face the force of the law. That's the implication behind a recent Dutch court ruling that Shell must cut its carbon emissions drastically to tackle climate change. Well, this has given hope to those who've launched similar lawsuits worldwide, maybe 1,800 such cases. Shell says it will fight the case, but that it is committed to cutting emissions. Very good to have your company. I'm David Foster. Well, some were clearly delighted, but the question is, where does it go from here? Is the pressure really on the big multinationals to change their ways? Or are we seeing legal fights that will go on beyond the time when climate change can be reversed? After a landmark case in the Netherlands, oil giants are being forced to take responsibility for their actions against climate change. Last month, the Hague District Court ruled that Royal Dutch Shell plc must cut its greenhouse gas emissions 45% by the year 2030. That is from 2019 levels.
CO2 emissions are responsible for dangerous climate change, and climate change has serious consequences for human rights, and the court finds that Shell has an independent responsibility to respect those human rights and also to reduce the emissions.
It was the first time that a court has found that a company has a legal duty to reduce its greenhouse gas emissions in line with the goals of the Paris Climate Agreement. Climate change activists and NGOs are stepping in where politicians have failed in holding companies and governments accountable to slash greenhouse gas emissions.
We expect a ripple effect across the other jurisdictions, because now once we have this first established liability of a company like this, we expect that this will have a ripple effect against other multinational oil and gas companies and coal companies in the world.
Activists in other countries such as Italy, Poland and France are taking similar action against corporations and their governments. So is the front line of the climate fight now in the courtroom? And will companies and politicians have to change their ways? Let's examine this in detail now. At this round table, we have Donald Pols in Amsterdam, Director of the Friends of the Earth Netherlands. In London, we see Catherine Higham, Coordinator of the Climate Change Laws of the World project at the London School of Economics, and in Cambridge, UK, Markus Gehring, Lecturer at the University of Cambridge's Centre for European Legal Studies. Good to have all three of you with us. Donald, when I saw you at the beginning of the programme celebrating outside the courtroom, I wasn't sure that you'd be able to make it today, because I thought you might have burst a blood vessel or had a minor heart attack, but you were clearly delighted. Has this opened the floodgates for similar cases?
I'd say yes, and to give you an impression of why I was so happy, we've worked on this for 5 years, so this was really the climax of 5 years of investment, personally and as a team. And already we have received requests from all over Europe and even from the US of NGOs that want to do similar court cases in their countries. And of course, the principles that are at the basis of this court verdict are applicable to all major polluters in all Western countries.
Is it indicative of the lack of will of governments worldwide that you had to do this, or is it indicative of their inability to put pressure on companies?
It's an indication of what we called a governance gap. And the governance gap refers to a very interesting fact that our basic legal system, our legal frameworks are based on the nation state that has been founded in the end of the 19th century, while our global economy is characterized by globalization, in which multinationals are the most visible example. And the multinationals that are responsible, 25 companies are responsible for half of all global emissions, are not regulated. They fall outside of the remit of the Paris Climate Accord and outside of the governance of nation states. And as long as we do not regulate multinationals, it will be impossible to achieve the objectives of the Paris Climate Accord.
Markus, you were nodding when you heard that from Donald. Catherine, I'm not leaving you out, but I'll come to you in just a moment. Why are these companies outside the power of governments and institutions?
The problem we have is that traditional international law frameworks are based on states agreeing with each other the rules of the game. Now, the Paris Agreement that was agreed in 2015 tries to move the dial a little bit into the direction of other stakeholders. The Paris Agreement itself refers to human rights, for example, or rights of minorities, and rights of indigenous peoples, but doesn't really directly regulate companies and businesses. There are now attempts to regulate businesses with national and regional legal frameworks. For example, you saw perhaps that the German Bundestag just passed the supply chain law, which tries to inject a higher level of accountability for global businesses.
So was this a recognition, sorry to butt in, was this a recognition that there were holes in the Paris Climate Accord, and those holes, because of what you're suggesting, are now being filled in?
Perhaps we need to think in governance structures much more broadly and involve all stakeholders, everybody who contributes to climate change, including multinational businesses. These kind of frameworks are relatively new. We have litigation at the national level and at the European level, trying to hold global businesses a little bit more accountable. But traditional international legal frameworks don't really capture businesses. And that is a little bit the problem that we're running into. And that's why I would argue we're seeing more litigation at the national level and hopefully soon at the regional level, because there's a human rights case pending in the Strasbourg Human Rights Court.
Okay. Catherine, coming at this point, climate change laws being your speciality, are we now seeing companies rather, being held properly to account?
Well, I think that's an interesting question, and it's interesting that you framed it in terms of climate change laws, because while we are tracking climate change laws around the world, and we now have more than 2,000 pieces of climate change legislation from nearly every country in the world, many of those laws aren't addressing the issue that Donald and Markus have just been talking about in terms of how do you regulate the global emissions of a company that may be headquartered in the Netherlands, but is, has operations all over the world and whose emissions, while being emitted at a particular point of source, are nonetheless sort of having a global effect. And so we are seeing more efforts by countries and governments around the world to introduce more regulation of greenhouse gases, particularly through carbon pricing, and trying to think about solutions to what has often been referred to as a problem of carbon leakage. So the idea that if you regulate greenhouse gas emissions in the European Union, companies may simply take their polluting businesses and set up operations outside the European Union, so you won't actually reduce emissions. And there's a number of sort of instruments being considered now, like carbon border adjustment mechanisms and other issues that would try and address some of those things. But I think that the reason that cases like the case that Donald has just been talking about are so important is that they go beyond this question of kind of carbon pricing and some of these regulatory instruments. And they really get into the sort of fundamentals of what is it reasonable to expect people to do and companies to do in the context of climate change, beyond, how you're being regulated. What do we expect in terms of responsible conduct? And so I think even as we see an increase in laws and regulations around the world, we will continue to see an increase in these kinds of cases as well.
Exactly. I was just going to come to a list or a map of some countries within Europe where cases are going on and then highlight some of them. There are cases in Italy, Poland, Belgium, Germany, France, the Netherlands, Norway, Ireland, United Kingdom, and Switzerland. The Polish one is Client Earth versus Enea, which is the fourth largest energy company in Poland, so energy there. Belgium, it's Client Earth versus the Belgian National Bank over buying bonds from fossil fuel companies, so not an energy company. And in the United Kingdom, it's Plan B versus Secretary of State for Transport, which is about the third runway at Heathrow. It isn't just energy companies that are being targeted. Catherine, is that a good thing?
I think it's absolutely a good thing. If you think about the climate crisis, you are instantly struck by the fact that this is a global problem, so it needs a global solution. And that doesn't just mean global in terms of the different countries that need to address this, but actually in terms of the different actors that need to address this. So it's one thing to bring a case against a company like Enea, I think that's an absolutely fascinating case. Perhaps we can talk about it later. But you also need to think about who are Enea's shareholders, who are financing Enea's activities. And there's all kinds of different actors that are actually implicated if we want to achieve a transition to a low carbon economy in the next 20 years or so,
Indeed.
20 or 30 years.
Indeed. Well, look, we will concentrate on some cases. The one that interested me was the one at the bottom, Switzerland. Swiss senior women versus the government of Switzerland before the European Court of Human Rights at the moment. We'll go into some detail in some of them. I want to come back to you, Donald, and ask you about what obstacles do you think were put in your way deliberately to try to thwart your case?
The biggest obstacle was, of course, the lack of finance. This was an enormously expensive court case for a rather small NGO like us. But we addressed this while formally the court case is called Milieudefensie, that's Friends of the Earth Netherlands versus Shell. In practice, it was the people versus Shell. So we had 17,000 co-plaintiffs and financial support is bringing up more than €500,000 in order to finance the biggest obstacle, which would have been our lack of financial capacity. It would have been really impossible to do this case if it was not for the support.
But even then, I mean, they've got
public.
billions and billions of dollars to call on, and 17,000 people, even if they give you $1,000 each, perhaps not as much as you need.
Very true. From a legal perspective, I'd say our most innovative approach was to address the policy of Shell as the main cause of damages. You would expect us as an environmental NGO to say the cause of the environmental damage is CO2, but we said the policy is the major cause. And that allowed us to base the case in the Netherlands, where the headquarters of Shell are and where the policy is being developed.
And sorry to interrupt, but does this ruling apply worldwide for Shell or just in the Netherlands?
It applies to all of the activities of Royal Dutch Shell Group globally.
And if you just could briefly tell us, what do you think the penalties are if they break any of these laws? Are they sufficient?
The penalties have not been identified yet. The Dutch legal system, like I think most Western legal systems, assumes that the Shell would just implement the outcome of the court. But if they do not, we will then have to go to court again and request penalties, which will be financial penalties. And it could be up to maybe hundreds of millions.
Markus, your turn. Ben van Woerden, chief exec of Shell, says society needs to take urgent action on climate change, but a court ordering one energy company to reduce its emissions and the emissions of its customers is not the answer. I believe Shell should work with our customers and their sectors to help them find their own pathways to achieve net zero emissions. Does he have a point? A court ordering an energy company is not the answer.
Well, certainly questions of climate change always involve also an element of public policy. But I think what the regional court in The Hague rightly rejected was this passing on defense, whereby Shell just washes its hands at its operations and says, we're not creating any CO2 emissions, it's all our customers. Well, but they're marketing the product that leads to these emissions, and that's what the court, in this case, in my view, rightly identified. I don't think it's an either-or question like the CEO made it out to be. I think all actors in society have to contribute to addressing climate change in a meaningful way. We're never going to reach net zero by 2050 if all actors just point the finger at someone else, and then government throws up their hands and says, "Oh, we can't do anything either." So
but
I think this sort of picking out individual actors has some merit.
Okay, but Shell has said it will cut or plans to cut its emissions by 50% by the year 2050. It is hardly being recalcitrant, is it?
No, I have to admit, and others on the panel might disagree, but Shell or BP are trying to be the better actors than some of the other companies in the sort of energy space.
Therefore, isn't it possible that they might feel hard done by if they're setting a good example and somebody tells them they've actually got to be better and better, whiter than white, they might be disinclined to do so?
Yeah, but the direction of travel is clear since 2015. It was agreed in the Paris Agreement. So all companies, all states have signed up to this global commitment. And now it's on all actors to implement it and to say, oh, we're already doing something. Shouldn't you point your finger at someone else? Is not an option, unfortunately. The consequences of climate change could be really devastating for life on Earth. And that's why courts increasingly side with the plaintiffs in these cases.
Which often wasn't the case, when I think it was normally for 3 cases that went to court, only one would be won by the plaintiffs. Catherine, let me come to you. You wanted to talk about Enea in Poland. By all means, feel free to do so. I'd quite like to hear about the Swiss senior women, but that may be beyond your scope. However, you were nodding your head in agreement to something that Markus said, so if you want to start off with that, that's fine by me.
Well, I was interested in picking up on what Markus was saying about the sort of publicity campaigns run by companies like Shell, and BP was mentioned, and others, because there have been a number of cases against these big carbon majors or oil majors, big energy companies that are responsible for a large proportion of emissions. And the defense in many of those cases has been, well, we only produce the product, other people burn it, other people use it. Didn't you drive to court this morning in your car, Your Honour? And I think there is, a really interesting movement now in kind of thinking about the fact that when we look at consumer protection law, we understand that false advertising or misleading advertising is very much the responsibility of companies that may have products that are harmful. And there's been some interesting cases, including a complaint against BP brought in the UK for false advertising for campaigns that essentially fall into a category that you would think of as greenwashing, sort of misleading the public about how many of their products are safe. So that's one interesting area to talk about.
Time is our enemy. If you want to talk about Enea, now is your chance. Otherwise, we'll move on.
So I think the Enea case is interesting because that was a case that Client Earth brought as a shareholder in the company of Enea. So I mentioned already, that there is a responsibility on the people financing fossil fuel companies to be thinking about what their money is going towards and how that money is being used. And Client Earth really took that literally. They bought shares in Enea and they brought a resolution around the company's purchase of a new coal-fired power station. And they said, look, this is actually not in the best interests of shareholders. This is going to be a really risky investment. And that resolution was initially dismissed. And the court in Poland subsequently said, no, Client Earth is absolutely right. And they ordered the resolution to be annulled. So I think that's a really interesting case because it shows that the litigants in these cases are, members of the general public, but they're also sometimes, people with more vested interests in the issue, who are trying to understand it from every angle. And this goes again to the idea that we need everybody to be thinking about and acting on the climate crisis if we're to address it.
Donald, do you think that with the number of volunteers that we saw in your case, with your call to arms for people around the world to join such lawsuits, that governments are going to come under more pressure?
Yes, clearly so. What we see globally and also in the Netherlands is what is called regulatory capture. It means that policymakers, governments, are very intimately involved with the multinationals and major polluters, and are therefore not taking the necessary action to protect our globe from dangerous climate change. So the only possible action is then for citizens to mobilize themselves and do stuff like climate litigation, because we cannot expect governments to take the lead. They will respond, though. Now we're expecting climate policy to increase because of the court verdict in the Shell case.
Does anybody want to talk about the Swiss senior women? Do you know that case, any one of you? Any hands going up?
I can talk about it.
Go on, I'm fascinated.
This is a case that was brought fairly early on in the sort of climate litigation trend that you saw post-Paris. And it was brought by a group of senior women, older women in Switzerland, who alleged that climate change is directly affecting them now. They're more vulnerable to heat waves than other sectors of the population, and that the Swiss government had an obligation to protect their human rights and prevent them from being sort of subject to the difficulties caused by these heat waves, and in some cases life-threatening problems caused by these heat waves. That case has been through the Swiss legal system, was lost in all of the Swiss courts, and is now pending before the European Court of Human Rights. And we actually see quite a few cases now pending before the European Court of Human Rights. I think it's 4 at last count. So that's quite an interesting development. And I anticipate that we'll be seeing some interesting jurisprudence.
I wasn't just having fun with the Swiss senior women, Markus. I suppose it's my way of drawing attention to the fact that it's not just young activists that care about this.
No, quite rightly so. I mean, we have to admit that some of the younger plaintiffs have been very successful in recent weeks. I'd like to draw attention to the order by the German Constitutional Court, which said that if you're emitting CO2 now, you're actually limiting the freedoms of future generations, of the generations to come. And the current young people will have to live in a much more carbon-constrained world with the limitations of freedom that brings with it.
Perhaps that's what they've been arguing for, and it's a question of be careful what you wish for. Donald, where does it go from here?
Yeah, the most important next step is our response to the probable appeal by Shell. We are expecting that Shell will be throwing the book at us, investing all the resources that they have. I think we caught them a bit unexpected by winning this case. And that is what we are currently doing, is preparing our response to their appeal. And maybe you would allow me to ask people watching, we need all the support we can get. We're up against a company that has an annual turnover of more than 200 billion, and we're expecting that they will invest a substantial part of that to try to win the appeal.
Okay, so whoever's listening to what Donald has said out there and wants to take part in this, feel free. You've just had an invitation from the man at the top in the Netherlands. You talked about unexpected on Shell's part. Was it very unexpected from your point of view as well?
Not really. Like I said, we prepared this for 5 years. And while listening to the defense of Shell, it was clear during the court procedure in December last year that we were really better prepared than Shell. So I could not expect anything else than a win. we did provide Shell with ample time to prepare their defense. Normally in the Netherlands, you have 12 weeks. We gave them 7 months to prepare, and still we won. And the reason why we gave them this time is we thought all the arguments need to be put on table for the judge to have a good outcome. And still we won. In the end.
You got the outcome that you were hoping for. Listen, thank you very, very much indeed. We could see what it meant to you as soon as the verdict was announced from our opening picture outside the courtroom. Thank you very much indeed, Donald. Thank you, Catherine and Markus. Much appreciated taking the time to come onto this programme. Hope to see you all again sometime soon. And wherever you happen to be watching this round table, our thanks from the round table team go out to you, and a request for you to tune in on another occasion. Until then, from me, David Foster, it's goodbye for now.